discussion. Judges?
Hi, I'm Hank Chambers, law professor here at the University of Richmond.
Hello, Kentucky. I'm Thomas Mackey at the University of Louisville History Department and the Brandeis School of Law here at U of L. Good to see you.
I don't think y'all get that as a special kudo or anything like that. I don't think we're going to let him grade just for y'all, but we're certainly looking forward to hearing from you. My name's Rita McCann, and I'm an attorney in Huntsville, Alabama, just a little bit to the south of y'all. Please tell us who you are.
Good morning, judges. My name is Haley Moore.
Good afternoon. My name is Eleni Parsons.
Hi, my name is Maggie Heingardner.
Hello, I'm Carissa Lewis.
Hello, I'm Lizzie Roding, and we represent Unit 3 from Highlands High School from the Commonwealth of Kentucky, and our teacher is Ms. Megan Boyman-Hennies.
Thank y'all so very much for being here, and thank y'all for all the work y'all have put in so far. It's been fantastic. We're going to jump right into Unit 3, Question 3. So I'll read it, and then we will get your opening statement. We'll hear your opening statement. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? We're ready for your opening.
At the Seneca Falls Convention in 1848, Elizabeth Cady Stanton helped draft the Declaration of Sentiments, which said, "The history of mankind is a history of repeated injuries and usurpations on the part of man towards women. Movements like these laid significant foundations towards achieving equality between the sexes, further expanded through the 19th Amendment and attempted ratification of the Equal Rights Amendment."
Both amendments were discussed as a result of vast women's movements. According to Professor Susan Gluck-Mezzi, a women suffragists in the U.S. were accused of undermining efforts during World War I, but they persisted, pointing to the hypocrisy of fighting for democracy abroad while women remained disenfranchised at home. After women's participation in World War I, the 19th Amendment was ratified in 1920, led by Harriet Stanton Blatch and Carrie Chapman Catt. Despite this, women of color were still disenfranchised.
The conversation over the ERA resurfaced recently as a result of the Me Too movement and Time's Up organization. According to Bridget L. Murphy, the context that previously fueled opposition to the ERA has been replaced by women's participation in the workplace, defiance of gender norms, and the aforementioned Me Too movement that highlights
Although both amendments worked to expand the rights of women, the 19th Amendment was limited in what rights it would protect, only mentioning the right to vote, while the ERA was more encompassing in its protections of liberties, broadening the goal to achieve equality of the sexes and prevent gender discrimination. Written by Alice Paul, the ERA states, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on the account of sex."
After the ratification of the 19th Amendment, several acts have been enacted to further protect the rights of females, including the Equal Credit Opportunity Act and the Pregnancy Discrimination Act. These laws created the Federal Reserve Board and the Equal Employment Opportunity Commission, which work to enforce that discrimination by lenders and employers does not occur on the basis of sex.
Furthermore, women, both nationally and internationally, have greater opportunities to be politically active. Elizabeth Yang, a member of the American Bar Association, stated that compared to the rest of the world, in 2019, the United States had the largest number of women in federal, state, and the local elective office. However, the U.S. has never had a female president, unlike other countries such as Pakistan. Benazir Bhutto, Pakistan's first female prime minister, was appointed in 1988 and became the first woman to lead a democratic government in a Muslim-majority country.
Under Article 5 of the Constitution, it is difficult to pass amendments as intended by the framers to ensure deliberation. Although the ERA was approved by the required 2/3 vote in Congress, it fell 3 states short of the necessary 38 for ratification, and therefore expired after its ratification limit of 7 years. Although it was past the limit back in January, Virginia ratified it, and now debate exists surrounding if it counts.
Additionally, according to Judith Afner, Assistant Director of New York State Division for Women, the federal amendment is the only means of assuring equality for women and men under the law. However, enforcement of state ERAs can help ensure that some citizens are protected against sex discrimination. But without federal enforcement, an individual's rights would vary from state to state and be taken away.
Advocates of constitutional ERA argue that focusing too much attention on passing state ERAs will diminish the ratification of a federal amendment. Jennifer Weiss-Wolf, the Women in Democracy Fellow at the Brennan Center of Justice, noted that the ERA would create a social framework to acknowledge systemic biases on a federal level.
According to constitutional historian Richard B. Bernstein, amendments like the 19th lay the groundwork for the further democratization of the Constitution and the nation. The 19th Amendment has led to significant advances in equality, and if ratified, the ERA would continue to expand rights for women in the United States and globally. Thank you. We are now ready for your questions.
Fabulous. Thank you all very much. I had one question. You all mentioned the Pregnancy Discrimination Act of 1978. Could we have a Pregnancy Discrimination Act of 1978 after the ERA is ratified?
Yes, we could, but the advantage of the ERA is that it would encompass a broader scope of women across the country. Progressive laws such as the Pregnancy Discrimination Act could be repealed or inefficiently administered.
And further to expand on what my colleague said, if we were to have the ERA on a national level, then it would diminish the need for these individual acts on a state-by-state basis, as all women on a national level would now be protected under all areas.
Okay, is the ERA about protecting women or about getting sex out of the law?
I would say, as it is written right now, that the ERA is more on account of protecting women, as during the 1920s when the ERA was initially brought up, women were still fighting for the rights and equality in society. So I feel like it's still for protection of women, but as well as getting the sexes out of the law.
Okay.
Yeah, well, that then raises and segues nicely into the relationship between the 19th Amendment, the proposed Equal Rights Amendment, but also the 14th Amendment, and most particularly the Equal Protection Clause. But I'm not sure how we jive with the need for an equal rights amendment and the Equal Protection Clause. Help me understand the relationship, if any.
The 14th Amendment has never been interpreted to make sex a suspect class like race, religion, or national origin, so the ERA would be necessary to include it as such.
The ERA would also make sex in the courts available to the highest level of scrutiny, whereas right now it undergoes an intermediate level of scrutiny, which makes women more vulnerable to certain types of sex discrimination.
And further
To
to
relate
expand
the
on that
14th Amendment to the right to vote, Minor versus Habitat proved that suffrage does not equal citizenship. Therefore, women weren't protected under the 14th Amendment's Equal Protection Clause. They gained the right to vote.
We got the right to vote, but we haven't had very many women elected percentage-wise to office. Do you think that is more cultural, or that is part of maybe a weakness in our laws?
I definitely think it's a cultural thing. If you look at Finland, almost 47% of their parliament is made up of women, and 23.7% of their Congress is made up of women as well. Additionally, they just elected the youngest female prime minister ever to the country. So I think it's a cultural thing.
How do we change culture?
Or because of systematic biases in the US, it's very hard to. So it would have to be a complete overhaul of how people view women in general.
And to further expand on that, in order to view that shift, people in society need to be aware that it is something to be acknowledged, and by placing amendments such as the ERA or the 19th Amendment, it's bringing more attention to that, idea, and it's showing that on a federal level it's being acknowledged, so that it is something that's being tapped in. So although that's not going to completely change it, amendments are a first step in that direction.
Yeah, it sounds like you've moved towards arguing that the ERA is more symbolic than substance, that any real change will come through cultural change. So therefore, isn't the ERA then superfluous? And we could just rely on the 14th Amendment's Equal Protection Clause as interpreted more recently.
I would not say that we can solely rely on the 19th Amendment, because the 19th Amendment, or sorry, 14th Amendment states that laws or amendments can be put in place to ensure discrimination. However, it doesn't state that laws need to be in place to not cause discrimination. So it's looking at it on a different level, and by ensuring and placing it solely on the 14th Amendment, it's not been as successful in society today.
I also think
is that a structural problem, or is that a cultural issue? I think that's what my colleagues were pushing you towards.
The 14th, in the section 2 of the 14th Amendment, it specifically states male citizens, and an ERA would allow the Constitution for the very first time to actually mention women. And we can see this working in other countries' constitutions, such as Belgium, which says that equality between men and women is guaranteed.
Izzy, you were saying something just a second ago, and I think you got interrupted.
it was just to add on to what my colleague Haley said. Justice Scalia said that the 14th Amendment does not protect discrimination against gender. Therefore, we cannot rely solely on the Equal Protection Clause of the 14th Amendment to prevent gender discrimination in this country.
And although it is largely...
You can finish.
Okay. Although it is very largely cultural, at the same time, it is very a part of the system, because women are not ensured to be protected from the things in the workplace nationally, like equal pay.
Thank you very much. Good stuff. Good stuff. So comments from my fellow judges?
Yeah, this is a tough question. On the surface, it doesn't look that difficult. It looks almost very easy. But in fact, you start thinking through the issues. You start thinking about constitutional structures, legal principles, as well as the cultural values. And it turns out to be quite an interesting mix of society, culture, and constitutional structures over time. And I think you actually mapped those out very well and sort of laid out some of the major issues and ideas that people have struggled with and that the culture is struggling with right now. So I thought you did a really nice job. Well done, folks.
I have to say, I liked that you all laid out the differences in 14 and 19. We've asked that question several times today and have not gotten a succinct an answer. I don't think until we got to today about what the 14th Amendment lays out versus what the 19th does, and what ERA could do if someone would bring it back.
Yeah, I think y'all did a good job. It's so hard to talk about what effects are going to occur because you start by talking about Seneca Falls in 1848. And then you've got 72 years before you get to the 19th Amendment. Right. And now we're 100 years removed from the 19th Amendment. So it raises the question of, if we were to get an ERA passed, would we have to wait another 100 years to then figure out whether it was a success? And that's painful. It's painful to worry about that. It would be much easier if folks, regardless of whether they were amendment, just realized we ought to do the right thing in small ways and big ways. So you all's notion of having to look at the question of what effect will amendment have, and then also deal with the fact that, well, we've got a 14th Amendment that in theory ought to cover all this stuff anyway, is real hard. So I commend you for the kinds of incremental analysis that you all were engaging in, because that's really what's going on with the 19th Amendment, 14th Amendment, ERA, and all that kind of stuff. So I think y'all did a very, very nice, very strong job. And I appreciate the the discussion that we just had.
Right. Well done.
Good deal.